saying,
welcome to Non-Obvious with Hugh Hanson.
yes, okay. Thank you, Nick. So this is our 8th episode, our 7th person, and we're very honored actually to have Nick Groombridge with us here today, who has not only a very interesting legal career, but a very interesting life with various things he's done. And we're going to discuss some of both. To start out, and I've done this with everybody, let's go back a little bit to your childhood. First, we just want to recognize that Don Nunner died in the last day or two, and what an incredible person he has been to the patent bar.
Yes, Don was very much a giant of the patent bar, who was really one of the leading figures when I wandered into the field some 35 years ago, and was ever since. And I believe that he had argued something like 125 appeals in the federal circuit, the most of anybody, or at least certainly the most of anybody in the patent area. And also that, interestingly, he was a member of the commission created by President Carter that ultimately led to the creation of the federal circuit.
He's an amazing person. I came to know him very late in his life, but everything about him has been quite remarkable, and he's on top of that, very nice guy.
He absolutely was, and remained greatly interested and active in the field of patent law. One of the last times I saw him was at the most recent International IP conference, when I found myself sitting next to him during.
Which conference was this?
It was the conference organized by a very illustrious professor at Fordham by the name of Hansen. Right.
And probably one of the best conferences in the universe, if not the best.
Clearly one of the best in the universe, and certainly the best on the planet Earth.
Okay. You were going to say something about him.
I just remember sitting there, finding myself next to Don, this probably 6 months ago, and getting into a conversation about one of the finer points of patent law with him. And his mind was as sharp as it had ever been.
And his energy level was actually quite remarkable. And I think he was 88 when he died. So it's a big loss for everyone personally involved, and also for the patent bar and patent law. Okay, so you grew up in Birmingham, England, which is part of the Midlands, correct?
Yes, or as I would say, the Midlands.
Midlands, yes. All right, yes, that'd be correct, Midlands. Tell us a little bit about it. I mean, what is it compared? What would be in the United States like Birmingham is?
Well, it was the Rust Belt, and so where I grew up. And I wasn't born there, and we moved there when I was about 3, which turned out to be too old to pick up the local accent.
Fortunately.
Perhaps fortunately, although growing up, the people would always regard me as this fancy Southerner who was kind of putting on airs and must feel that he was better than everybody else.
But you were, and that did describe you, actually. No, I'm joking. Yes.
Hugh himself has experienced this, so he knows of what I speak. But the area where I grew up was still and had traditionally been a manufacturing area, a lot of heavy industry, metal, making things out of metal, and it had thrived during the Victorian era, when it really was kind of like the Silicon Valley of England. And then it had also not been hit hard during the Great Depression, unlike much of the rest of the country. But in the era when I was a child, it was experiencing hard times. And particularly in my teenage years, the industry was very much in a state of decline.
And where is it today?
I think that stabilized and maybe even bounced back a little, but it's still, the town that I grew up in is very much one that is kind of down on its luck.
Are your parents still there?
They are, yep. They still live in the house that they had when I was a child. But for example, that town voted something like 70-30 in favor of Brexit, which I think you could take as a sign of dissatisfaction.
Yeah, absolutely. So, okay, your mom was a humanities professor and your father was a science professor, which usually the two don't meet, don't even date. So, what was going on there?
Well, you say professors; they were really teachers more at the secondary school level. But they
Okay.
did. There was a constant debate in the house. I wouldn't necessarily say which is better, but there was always a kind of back and forth between the humanities and the arts on one side and sciences on the other, and with the attendant kind of views and prejudices that one might imagine, always in a good-natured way, but the sense that on my father's part, for example, that people who studied literature did so only because they weren't smart enough to study science. And on my mother's side, the sense that people who studied science couldn't write a sentence.
So, did you take sides as a child?
I actually tried not to. It was a delicate situation, but I would prefer not to. And in fact, I think you know this, that the reason that I went to study law was because it wasn't science or humanities, and so it was in some ways a neutral pick.
Brothers or sisters?
I have two brothers, and they both studied science.
Yeah. And where are they now?
They both live in England. One of them works for the tech consulting firm Gartner, and he's basically a high-level tech consultant.
What part of England is he?
He lives not far from my parents, about 10 miles away. And the other one lives outside of London and works for a subsidiary of Schlumberger, and he's a geologist. And I think at this point he mostly manages people, but what he has done historically is analyze data and say either do drill for oil or don't drill for oil, which turns out to be complicated.
So, at some point, probably right after high school, you went to LSE and studied law and got an LLB, correct?
Correct.
And you could have gotten a lot of different things and still not had to choose between your parents. How did you choose law?
I actually had a relative, an uncle, an American, lived in New York, who was a lawyer by training, although he then, after practicing law for a while, became a political science professor. But it was, I think, through talking to him that I became interested in this. He wrote a lot about constitutional law and democracy and things of that nature, and that appealed to me and got me thinking about it, and that probably started the chain of events that led me to pick law.
So how was the effect of the experience at LSE it was on you? Was it like, wow, this is great, or maybe it's great, or?
I think at that point it was more maybe it's great. I mean, there were parts of law that appealed to me intellectually, but the idea of doing it for a living, I don't think at that stage of my life was something that I looked at and said, wow, that's awesome.
So you get a degree and then you travel the world for 3 years or 4 years or something?
Some number of years, right? That for whatever reason, when I got my degree, I and my then girlfriend decided that it would be good to see the world. And that led to me selling my possessions, such as they were, and buying a one-way ticket to Rio de Janeiro. And spending, I think it was 2 years in Brazil.
And your girlfriend went with you?
She did, yes.
Did she have any say in this, or did you choose it together, or what?
We chose it together, and she certainly had a say in it. I think it was probably more her idea than mine, but one way or another, it was a joint decision.
Okay. And what were you doing there?
Well, we arrived there. I think we thought that we would teach English, and in fact, that is mostly what I ended up doing because if you don't speak the language, it's hard to do other things. Um, but it turned out to be harder than we had expected to line up that kind of work, and took a while. So we spent some short amount of time in Rio, decided we didn't like that, and then went to a city that is about 1,000 miles north of Rio called Salvador, and settled there.
And her parents have hated you ever since.
Well, I don't think her parents cared that much about it, and we split up, right? And not to put too fine a point on it, she dumped me Christmas Day, 1981. I'm sure she had good reason to do that, but that was sticks in my mind for some reason, right? What I would normally say about that is it turns out that if you're in a relationship that's not working too well, the way to fix it is not to go to a foreign country where you don't know anybody and have only one another for company. So we parted ways, and she went back to England, and I stayed there for some while longer, and did end up being able to make a living teaching English. And ultimately,
Ultimately, you said,
mhm.
I think I might want to be a lawyer, but you went to the U.S. rather than back to England.
Well, so I had, the way I recall this was I was leaving Brazil, and I traveled north through a lot of very remote parts of Brazil and then through the Amazon jungle, which was an interesting journey
Wow.
up the river in small planes and small boats.
You know, actually, your autobiography, have you started that?
Who would want to read this? Right.
Uh,
We'll see if this podcast attracts any attention. Right. But my plan was to travel north. Now, for some reason, as I remember this, was the beneficiary. I was very lucky of a small bequest from a family friend. But the way I remember it was I had to go to New York to get the money, and so I was making my way north, and I actually arrived in Miami with about a couple $100 in my pocket, and then traveled on to New York and to pick up this money and also stay with my relatives here. And that set in motion a chain of events that has resulted in me living here for the last 35 years.
Yeah. Now, you started out as a paralegal. Is that because that's the only job you could get at that point?
So what happened was I met my wife, who was then studying, still in getting her bachelor's degree, and we did a kind of transatlantic relationship for a few months.
Oh,
And
hold.
yep,
Where did you meet your wife?
she was my cousin's college roommate at Barnard, and that was how we met.
And you met her in New York,
I met her in New York.
and then you went back to England.
Then I went back to England, and she came to visit me, and I was coming back to visit her with the idea that I would be here for a few weeks and then go back to London. And at some point in that, we said, "This is crazy. Let's just get married." And so we got married in City Hall, or actually the municipal office building downtown in New York. We told our parents afterwards. I remember essentially calling up and saying, "Good news, you saved a lot of money on a wedding."
And so her parents hate you as well.
They did at that point. They were
Yes.
like, "Who is this guy?" And he's only marrying you for a green card, right? I think over the ensuing years, they decided that maybe I wasn't so bad after all. But at that time, they
But
weren't
you know, most parents
overjoyed.
want to see their daughter married, not
Um,
get a telegram about it.
yeah, exactly. They don't want to get a phone call
Yeah.
saying it's already happened, right?
Okay.
But having got married, and we got married January the 5th, 1984. And she was going to complete her studies, graduate in May, and then the plan was we would move to London. I needed to go out and find work. I was legal to work, and I wanted to pay the rent, basically. But it turns out that if you tell potential employers, I'm only going to be in the country for 5 months, doesn't do much for your prospects. And the only job I could get was being a temporary paralegal.
Okay. I never even heard of that position, temporary paralegal as opposed to paralegal.
Yeah, so I worked for an agency.
Okay.
Right. And in those days, this is a job that wouldn't exist anymore because now it'd be done by machines. But in those days, if you wanted to get ready for a deposition, let's say, in a lawsuit, the way you would do that would be have a team of people go through a file of all the documents that might be relevant. It could be 100,000 pages, 150,000 pages, something like that, looking for terms. An exercise that today would be done by running search terms in a computer. But that was done by paralegals, and frequently it was done by temporary paralegals where the law firm would say, we have a lot of this work to do over the next few weeks or months. We don't want to hire people on permanently, but we'll call up an agency.
Okay, so you're basically there for discovery and through an agency. Okay,
yep.
I understand that. So then what happened?
Well, I was a temporary, turned out my first and only assignment was to a law firm called Fitzpatrick, Cheller, Harper and Sinto, which turned out to be an IP firm, patent and trademark firm.
And it was IP boutique.
It was an IP boutique at that point. Probably
a very good one.
A very good one. And at that point, probably 30 or 40 lawyers, something like that. And I went there, and what was supposed to be a 1-week assignment, that turned into a 17-year association with the law firm.
And how did you have a science background in no?
No, I just had a law background.
And so you could have been doing trademarks, you could have been doing copyright, you can do patents. You ended up doing patents. How did that happen?
Most of the work there was patents, and my job, by and large, was to organize files and also spend days on end going through these files, saying.
I'm talking about now when you were an associate.
They hired me on as an associate to do patent work, and all I ever did was patent work. So I guess at that level, that's how.
Did they know you knew nothing about life sciences?
They knew that I think you could fairly say that they thought I was good at learning facts. I think they also thought I didn't know much about the law, and they were going to see how this would work out. Right.
So there are those who say to be a good patent person, you have to have been born and bred one and basically taken life sciences or something technical stuff in undergraduate school. So you have certainly showed that that's not the case, but are you just a very rare thing? I mean, would you only hire people who had full science backgrounds undergraduate?
We do. We do not have a policy that we will only hire people with science backgrounds. What I would say typically is I'm perfectly happy to hire someone who has no science or engineering background, as long as that person convinces me that she or he is deeply interested in this and is not intimidated by complicated subject matter. And typically, though, at least 3/4 of the people that we hire do have some kind of science or engineering background.
Okay. In terms of litigation, there are those who say, actually, there's a lot of things you can do as a patent lawyer, but in terms of just hardcore litigation, especially with juries, there's an advantage to not having a science background because you can put yourself in the position of the juror and start from the beginning going up. And if you've been doing this whole life, you really sort of start in the middle and go up. Is there anything to that?
Some people certainly say that. I'm not sure that I agree with that. I very much agree with the premise that you need to be able to put yourself in the position of the listener. I'm not, and certainly there are times when you find people whose own education complicates that because they take things for granted and can't step back and see that they're taking that for granted. But But I see plenty of people who have science backgrounds who are perfectly good at doing that, and I also see people who lack science backgrounds who are bad at doing it. So while there may be some association, I don't think there's a hard and fast rule there. I think more what you're looking for is someone who is able to empathize.
Okay. So right now, probably you know more life sciences stuff than almost anybody with all that you've done.
I know a lot, but remember that because I do litigation, there's a time lag, right? The science has to be done. It has to have worked its way through and probably resulted in a commercial product, which often takes a lot of years. And then the commercial product has to be successful enough that there's a pot of money worth fighting over. And so typically the cases that I handle, the science underlying it was done, often 10 years ago, 20 years ago, that kind of thing. It's not that we never have a case. Actually, do have a case right now about completely cutting edge science, but often a lot of what we're learning are things that were very new some while back, but now the science has moved on and people take this as pre-established
Is there any
stuff.
distinct difference of trying a patent case from trying any other type of case or copyright, trademarks, or even non-IP? Are there certain things about that are simply different than?
I think in terms of trial technique, I don't think there's a difference at the level of technique. What I would say, though, is this, that part of what attracts people to the patent field is that it's a very, very complicated area of law. And unlike many civil cases, there's very often a trade-off. If you make this argument, it hurts you on that argument. And so there's far more complexity and interaction in it. And when you try a case, you have to be cognizant of that. And so while the techniques that you would use, I think, are the same as they would be in any trial, you've got to be careful to not do something that will hurt you down the road. And that tends to be a much more prominent feature of patent trial work as opposed to a contract case.
Okay, jurisdictions. The Southern District of New York, the Eastern District of New York, Central District of California, Northern District of Illinois, which I imagine you go there and get pretty savvy judges for the most part, as opposed to then out in the hinterlands. Or am I wrong?
I think those ones you mentioned, you would have pretty savvy judges. And I think also now, because of the patent pilot program, you can have more of an effect of the judges can pick that they want to do this. And so you don't end up with a judge who is unhappy about having been assigned a case.
That's a big advantage.
It is a big advantage. And I think, you will certainly see in those jurisdictions that you mentioned judges that are very keen on patent cases. They like them. And that's a good thing. You could, though, particularly in the larger ones like CD Cal or the Southern District of New York, you could end up, if you've got 30 judges in a district, you could end up with someone who is not overjoyed about having this case.
Is there a problem with the very experienced judges, and the UK is an example of this, so where you have fewer judges who basically hear almost all of the patent cases at first instance and then Court of Appeal, or most in the Court of Appeal, and certainly most. And that after a while, I clerked for two judges, one in the Southern District, one in the Second Circuit, and the more the judge knows about an area, the quicker the judge makes up his mind or her mind about it, and the less influence the advocate has. And I know in the UK, some people complained about some of the judges it was pretty much, after the first day or something, it was clear the judge may have made up his mind, and it was very difficult to get him off. And I've actually spoken to some of them, and they say that actually is an issue. So going back to this country, have you found that to be a problem in this country?
I don't typically find it to be a problem. I mean, I'm certainly aware of that as a phenomenon that can take place sometimes, but to me, that would only be a problem to the extent that the judge was making up her or his mind and getting it wrong. and being unwilling to reconsider. And I've had situations occasionally where I thought that had happened. I've had situations where I thought a judge was influenced by the type of case it was, or the identity of the parties, big and small, that kind of thing. But that's rare. I mean, mostly I think what you get is, look, I've also had situations where a judge appears to make a decision early on, but I think that's the right decision. And stepping back, if I were the
Or
judge,
just happened to be on your side.
or even where I was going to lose. I mean,
Yeah,
often,
okay.
one of the things that I try to do is, if I lose a case at the time, I always have the view that, well, that's wrong, because I've convinced myself that I should win.
Mm.
But I try to look back at it after 2 or 3 years and say, what really is the right outcome there? And very often when you look at it, you can say, dispassionately, if I were presented with this set of facts, that's the way I would come out with it, right?
Mm-hmm.
It's certainly not an unreasonable outcome.
All right. Back in the day, and certainly when I
Mm.
started in
Mm.
IP, all of patent cases were basically non-jury. Now, almost all of them are jury now. Is that right?
If you have to, I think, take out the Hatch-Waxman cases, the
Yeah,
Anger
yeah,
cases.
yeah,
But
yeah,
if
yeah,
you
yeah.
if you take them out of the calculus, the
Yeah.
overwhelming majority are jury cases.
Now, you as an advocate, if you could have all the cases, and this is the hypothetical, and you have to choose one or the other, all of your patent litigation would be before juries, or all of it would be for a judge in the district court. Which would you choose?
I'd choose juries.
And
Why?
yeah,
Partly that's a selfish decision. I mean, my view of the world as a trial lawyer is that trying a case to a jury is a more demanding, more challenging, and more rewarding task, and that it forces you to be better, that you have to make hard decisions about what issues you're going to present, have to be on your game all the time. Modern jurors expect lawyers to be like people on TV, right? And you've got to figure out how to tie everything back to themes. You've got to manage your time more rigorously. So all of these things make you a better courtroom lawyer. And that's part of it. And ultimately, do I think that juries get things wrong sometimes? Certainly. Do I think that they get them wrong more than judges? It's hard for me to say that. I mean, when we get in this debate, which often happens with foreign lawyers who think the jury system is crazy for patent cases, I would say, well, okay, how many of you have had a decision where a judge ruled against you? And they'll always raise their hands. I say, and how many times did you think the judge was completely wrong, or she or he had misunderstood something fundamental? They all say, yeah. So that because you get a reasoned decision, but the jury did that, you would say that it was just born of stupidity or misunderstanding, right? And when you look at the percentages, I have a hard time saying that judges reach the wrong decision more or less than juries, right? That ultimately, the other thing I would say about juries is that they're extremely good, and you know this, at figuring out when someone is not being forthright or when they're being spun, right? They may not know why, but they can say, this
Yeah.
person is trying to convince me of something, and I need to be skeptical. And you don't need any degree of training to do that. That's human beings are good at that. My experience of juries is they bring that to everything they do. And overwhelmingly, they try really, really hard. And I had a case in Las Vegas, because it was 4 years ago.
Why were you in Las Vegas?
So the reason we were in Las Vegas, we were representing Garmin, the GPS company, which I've represented for a long time. And they had been sued by what I could charitably call a non-practicing entity that had set itself up. There was really one individual, and he had set himself up in Las Vegas because he liked living there, and he wanted to cloak himself in the mantle of being a Nevada native. So the name of his holding company, the particular one that was involved there, I think, was Silver State Intellectual Property. And he began his testimony with what I thought was fairly cringeworthy way to tell the jury how much he loved Nevada and how he was a real Vegas guy. That's why we were in Vegas. They had filed the lawsuit there, and that's where it had stayed.
Now, do you ever think in those situations,
Mhm.
file the declaratory judgment action in a different venue just to avoid that?
Very often there is that kind of skirmish increasingly now after the TC Heartland case. But let me just say the reason I raised that case in Vegas was this, that it was the judge there allowed the jury to ask questions. They had to do it in writing. And like many trial lawyers, I had never been a big fan of having the jury ask questions. Now, here we had a jury of, I want to say it was 10 people, might have been 8 though. And they worked incredibly hard. And one of the questions we got was this: after a patent has been granted, can it be revoked? If so, on what grounds? Sameness or similarity? You think about it, that's an awesome question. That's a real human being way of asking about what patent lawyers would call anticipation and obviousness.
Mm.
And I was just blown away by that question, right? And it was one of a number that were like that, right? And to me, it was a real insight into these people are trying really, really hard to do the best job they can. And, it didn't hurt that they came back with a complete defense verdict either. But,
What percentage of cases do you win?
I don't keep track of the percentages, but I know it's gone down over time. And one of my partners said to me, maybe it was last year, that he had realized that the days of sweeping all before us were over because people now only hire us for really hard cases.
Yeah. It's, I mean, that's the irony. I was in, it was attorney's office in the Southern District, and then at Dewey Downtown as a litigator. And what I found, it's amazing how many, quote, litigators really don't want to go to trial, and they really don't want to go to trial before a jury. They'll love the rest, summary judgment, preliminary injunction, discovery motions. But, and I think one of the reasons is, there's a number of reasons, but one of them is, even if you were the best lawyer in the world and did the best job anyone could do, you could lose, and the rest of the world would just see that as a loss. You get a C in your report card, you can tell mom, dad, the teacher really, and no one believes it. And in the same thing, if you lose that, that's on your report card.
Absolutely. And, if you're going to do trial work, and I don't know that jury trial work is any more or less this way, but certainly people perceive it this way. You are going to put yourself in a position where you're very out there. You've invested in something very publicly, and you don't have a lot of control, you feel, over how it's going to be decided. So, you could do the best job in the world, you could outlawyer the other side and lose, right? And that's not actually that uncommon, right? And so you could do that. What I see in that is that true trial lawyers tend to be superstitious. Almost all of them are superstitious. And that manifests itself.
Give me an example of that.
Yeah, I have a former partner who's a very accomplished trial lawyer, and he and I used to try cases together. He has a superstition that when you go to court, every day you have to have the same position in the car that you had the first day you went to court. So if he and I sat in the back, right? So I remember the way I learned this was we were going to court. We were trying a case in, I think it was in Dallas, and we were riding to the courthouse in a huge SUV, probably a Suburban. And he and I, the first day, got in and we sat in the way back, right? 3 rows of seats, and we were in little cramped seats in the back. And then every day after that, he said, we've got to sit in the way back because if we don't, it'll be bad luck. Right. And that's symptomatic of the kind of superstitions.
Actually, that's a little scary, right, that story.
Well, we end up winning the case. So,
right.
Maybe he was right.
Could be. So if you're trying to determine or tell someone about, they don't know, I'm going into licensing, I'm going into obtaining a patent or litigation, or what skills would you say to that person you really should have or be able to develop if you are going to litigate?
Well, I think ultimately,
or personality traits, whatever, however you want to describe it.
I think ultimately, if you're going to be successful in the litigation business, you have to like telling stories. And now the stories have to be true if it's in the litigation context, but you have to like saying, how am I going to take this complicated body of information and make it interesting in some way? So one of the things that I'm fond of saying is, look, if I'm doing my job right, and let's say it's the opening, and I'm talking to the jury, if I stopped in mid-sentence, they should involuntarily lean forward slightly and think, I wonder what happened next. Right? And because that's the way it has to be presented. And so ultimately, what I would say is you need to have an interest in that. You need to like the facts. You need to like learning something complicated that has nothing to do with your life and figuring it out and turning it around and saying, how am I going to work with this to get the outcome that is best for my client? Now, within that, the sort of tools of the trade, right? How to take a deposition, or how to write a letter to the judge, those kind of things. You need to learn all of that too. But if you have the intellect to do well in law school, you could certainly master those kind of things.
How often? No, you're at the very top, so this may not be a good test. But how often do you find the lawyer on the other side has the skills in a way that's really impressive?
Fairly often. I mean, I'm in a fortunate position where I'm usually up against sophisticated adversaries who are very good lawyers, and frankly, that's one of the things that makes the work more satisfying.
All right. Now you have won some really big cases and made ridiculous amount of money for your client.
Maybe.
So what?
Maybe. Right.
No, I know for a fact because I've looked it up. Are you rich beyond belief?
I'm doing very nicely. I don't.
You're comfortable.
Well, I would say I have made a lot more money than I ever thought I would. Right? And look, again, one of the things I say though is different people define rich differently, and even people who really are rich often don't think of themselves that way, right? Because they're looking at whoever has more. But if you want to really make the kind of money where you don't have to work every day, right, then the practice of law probably isn't the right place to do that, right? That you go in the financial services industry. Basically the ways to make that kind of money are either by selling something in large quantities or by arbitrage, speculation in some fashion, right? But those are the only ways that you can make money at that level. Now, for a working stiff, I'm doing very nicely.
Well, again, this is the difference between. First of all, do litigators make more money than other patent lawyers in the firm because of the nature of litigation?
I mean, when I lived back in the world of IP boutiques,
yeah.
The litigation side of the firm was regarded as the more profitable side. Often that meant that it had more clout within the law firm, and the other practices like prosecution, trademark work, and so on were regarded as less so. I suspect.
Did you even view trademark lawyers as lawyers?
I most certainly did, right? I'm aware of, a lot of people in the past who have said derogatory things, and basically they all boil down to, the whole question is how close is too close, and that's it, right? But you're a trademark lawyer. You know that there's a lot more to it than that, right? And also, if you're at a cocktail party, trademark lawyers are a lot more interesting than patent lawyers.
Oh, I'll just tell a little story. The annual, it used to be patent groups stayed by themselves. Now they call themselves IP and they do all. But in the days of which there was actually an annual meeting of the patent group with trademark or copyright, the patent people would be sitting there. There'd be some music and no one would be dancing, and the wives would maybe speaking to each other or something. But the copyright people really sometimes had string quartets and this other things. Of course, they weren't going to dance. The trademark people had a band, dancing, fun, really, enjoying life more of the situation. But again, that's not my
Well,
point.
it reminds me of something. When I was back at the Fitzpatrick farm, one of the things that I would do from time to time was go off and do recruiting. And we would go to law schools, and typically there'd be 3 or 4 of us, and we would speak to a room full of law students. And we'd try and persuade them that what we did for a living was really awesome and that they should come and do it. And if you went with one of your trademark colleagues, you always lost out because he or she would turn up with a bunch of things, from cases that they had had, right? And they would always be like, it was very much like, if you perform with a child or an animal, then you're going to be upstaged, right? It was like these people would show up and they had stuff that looked like fun and they could tell these great stories. And I would be, well, we had this awesome case about Section 112, right? And so that's what I mean is if you're going to be at a cocktail party, make sure you stand next to the trademark lawyer.
And by the way, just for the record, I consider myself a copyright lawyer who does trademarks, but I love them both. So my experience actually is litigators are really a different type of people. Like I feel I was born to lit. I love the battle. I love it. I look forward to it. On trial, I'm like, it's like Werewolf in London. This innocent person gets bitten, and all of a sudden his ears, he can hear everything 10 miles away and everything else. And I just love it. But I think the litigator's life is more difficult on scheduling, on stress, and a lot of things. And if you're not actually want to do that battle, it can be kind of an unhappy experience.
Yeah, I think that's right. But and the further along you get with it, the more so that will be, right? So, that you have to be willing to travel a lot. You have to be willing to accept that you may not have control over your schedule. If you do work for an international client base, you're going to have phone calls at weird hours. If you and when you go to court, you to me, trial is the ultimate thing. It's it's the show, right? And that's what we live for, right? But surprisingly to me, there are people who don't like the idea of working 18 hours a day in a high stress environment, right?
Okay, now you happen to be an area of the law that a lot of people think is currently in crisis, at least in the United States. Would you agree with that?
You mean patent law as a whole or some subset of it?
No, patent law as a whole.
I don't think it's in crisis. I mean, when people talk about that, usually what they're talking about is patent eligibility in Section 101.
Yeah, probably.
Right? And I think the law is unsatisfactory, and confused in that area. But look, that's a part of patent law. It's not the only thing there is, and it doesn't. The forces that created that state of affairs did it in reaction to a set of other things, to a need that existed in the system. It may not be good where it is, but it's moving, right? And
moving in the right direction.
I'm not sure if it's moving in the right direction, but it's moving. And at some point it will come to the right place, right? And so that's how I would look at it. I don't see patent law as a whole being in a state of crisis. They do see that short-term fixes or perceived fixes to underlying problems often create new problems. And so we have this kind of dialectical situation with patent law where it's certainly moving. And at some point, at least in any given issue, it will reach equilibrium. But how long it takes to get there is hard to predict.
All right, let me give you my view of what's recently happened as a non-patent person. So I'm looking from the outside. It seemed to me for many, the Court of Appeals for the Federal Circuit was specifically, and there's no doubt about this, created because regular judges were killing patent law. They thought everything was obvious, this or this or this. And if we were going to have industries, incentives, all these things, something had to be done. And even someone like Ted Kennedy, one of the most liberal people, was in favor of creating the Court of Appeals for the Federal Circuit. and which was basically meant to correct that situation. And for, I don't know what, 12, 20, something amount of years, Supreme Court didn't even grant cert. But then, for whatever reason, and in the beginning, the Federal Circuit people were picked in a way almost, even if they weren't a patent lawyer, with sort of this in mind that our job is to do this. And that sort of, then you got people appointed who, basically worked on this committee, and it had nothing to do with IP or something else. And you got people who weren't as enamored of the idea that IP or patents should be protected. And what you then had was the Federal Circuit splitting. And so you had, who was on that panel was actually very important, perceived as what lawyer would get. In fact, that's why they didn't announce panels in advance anymore, because they thought that lawyers were
pandering.
Yeah, and then I think a couple banks in which it went 6-7 or something like that. And Supreme Court and the rest of the world is saying, on top of this, the rest of the world is saying there are a lot of bad patents, and this is because there's software, there's bio, there's way to run a business. All these things are being rather new. There's no prior art, a lot of things, so the examiner has nothing to knock out this stuff. So what you're flooding now is a lot of bad patents, and it didn't seem like the system was interested in trying to correct it. And then you have Breyer in the Supreme Court, who's been an IP skeptic, not trademarks, but everything else, dissenting from denial and cert, and finally said, okay, we'll grant cert, we'll try to do something, and gave him the case, which the name of that case is?
Which you're thinking of?
The first one.
Mayo?
Yeah. And now, he writes, his prose was all Breyer, but then we're not overruling this, we're not overruling that, which the other judges are putting in, justices and thing. So if you actually look at it, they thought they produced a fairly narrow thing. But there's just someone out there in the world, it looked actually like it's pretty broad and it's going to knock out a lot of stuff. And I don't think that was the plan of the court. And the court, a couple of other cases, it's having trouble correcting it. And I think right now it doesn't want to touch a patent case. And of course, Congress is useless in this type of thing because the whole industry has to agree for them to do something. So, and there's still something of a split, maybe not as much. So what is your view right now of, you're appearing in a court of appeals for the Federal Circuit, or you're on the outside wanting to make sure the law is righted? Is there any way you could do that?
I think if you left the Court of Appeals to itself, it would evolve a body of rules that would enable much better application of the principles in this area. I think you've got a problem which you see most sharply in the Athena case, where a lot of the court believes that its hands are tied. So where we are with Athena is typical of these diagnostic cases.
So the Federal Circuit basically denied protection. Was that 2-1 or 3-0?
It was.
I thought it was 2-1. Maybe I'm wrong.
I think it was 2-1, but I actually don't remember. What I remember was that there was then a request for rehearing en banc, the full court, to hear the case. And in July, the court denied that, voted 7-5, the 12 active judges, not to take it, although all 12 of them agreed that the law was wrong.
Hold it. All right, go on.
So we have this highly unusual cry for help that consists of 8 separate opinions.
Well, all 12 can't, because you had at least 2 or 3 who said the law is that.
No, they all say the law is wrong, or at least the law is bad, right? It should be different. The point of.
Oh, all right. Now, when you say the law, you're talking about the case law That's binding.
So you have
Okay,
seven
I got
judges
it.
saying
Okay, yeah.
the law ought to be different, but we can't change it. We're
Right.
compelled by the Mayo case to reach this
Yeah.
result. We have 5 other judges saying the law is wrong, we can change it. We're not compelled by the Mayo case, but you have 12 judges saying, in my opinion, the law is wrong.
Yeah, but what I disagree with you on that is I think some of those 7 were using that as an excuse. They actually did not think the law was wrong, and they actually would have reached that decision on their own. But it's easier to say, don't blame me on this, blame the
I think
Supreme
there's a
Court.
gradation. I think when you come to the area of the life sciences, a lot of the people who are very keen on the application of Section 101 to software patents are actually much less keen on it. And you know, it's hard to draw a conclusion other than that we have moved the law to a place where diagnostics are effectively unpatentable. And I don't think there's anyone on the court who would agree with that.
But my view is this: in the past, the Federal Circuit didn't. I mean, if you look at Judge Rich, way back when it was CCPA, he told the Supreme Court to go screw themselves when they remanded for reconsideration, and he said, "No, this is wrong. I'm not that Supreme Court case. We're still doing it," and then went up, and the Supreme Court actually affirmed. So you used to have judges there who would say, you know, no, we're going to determine what it is. And if the Supreme Court wants to reverse us, they can reverse us. We have the expertise. And I think it's not that they don't have the will. I actually think some of those judges are okay with this thing. But so you have 2 of my favorites who did what God intended, Judge Moore and Judge Newman, were in the group who said, this decision was wrong, we should reverse it, right?
Yeah,
Yeah.
but they say we can change the law when our hands aren't tied by
Yeah. And I think they all could have. And if there was a will, I think they would have. I just don't think, for some of at least, there was a will.
Well, I think you've got to, there's certainly a constituency on the court that thinks that 101 is doing very valuable duty. And not in cases like Athena, but in all the software cases where you've got a perceived set of problems with bad patents, and that it's difficult to have a mechanism to weed out the bad things, and 101 has become that. And to me, you can't look at this area of the law without also taking into account the procedural pull for this to exist. And what I mean by that is that you can knock out a patent on a Rule 12 motion now, which was effectively impossible for decades. And
what is Rule 12?
It's a motion to dismiss, at the beginning of the case before you would file an answer. So you get sued. And a big part of the reason why the tech industry has dug in its heels so and said, we absolutely have to have this and the law is right, is because now if you get sued, someone comes out of the woodwork and says, hello, Facebook, you're infringing my patent on such and such, right? You can go to court and have a realistic chance of eliminating that at the very beginning before you have to spend millions of dollars on discovery and all of these things and go through it, and then maybe knock it out on a summary judgment motion, right, after a couple of years. And the system was lacking that means to weed out bad cases early. And that's a big part of why this came into being.
Well, a motion to dismiss historically has been considered ridiculous. And if a lawyer brought it, the judges would think there's something wrong with the law. I'm not talking about just in patents, but in the others.
I don't think that's so. I mean, I think, for example, there are many areas of the law where motion to dismiss is expected. It's a huge
well, the motion to dismiss says that even
if
if all this is right, you still lose. And that's going to be very, very rare. If a lawyer brings a case in which that can be said against it, it's just bad law.
I don't think so. No, I mean, I think if you look at the private antitrust bar, right, where they're bringing often very creative antitrust cases, you look at the securities plaintiffs bar, things like that, those kind of cases where, a lot of those cases are decided on at the Rule 12 stage, and that's been true for a long time.
Well, yeah, that's what is going on. Rule 12 is basically if everything your party says is true, you still lose. It's been basically pushed up to some sort of you're wrong on the law, which is not what that was not the dismiss. That was summary judgment or something else. So what has happened is the courts have. It's amazing actually how many cases you have on to dismiss, and I think they're responding to exactly what you're talking about. We've got to act sooner, but it's not saying we're changing this to something that has more teeth than it ever had before.
Absolutely, but there's a systemic pull for that.
Yeah.
Right, and that's what I meant when I said, look, the system will evolve. It will respond to tensions and needs, right, with developments which may then themselves create other problems. And that's exactly what we see with 101, that the reason for the emergence of this law is that we ended up with a whole lot of software patents. Within that, there were good ones and bad ones, but when people sued on the bad ones, a very limited way to weed those things out. And so this evolved as that mechanism. And, that it's hard for me to quarrel with the idea that there should be a mechanism for quality testing patent cases at the front end, just like any other case.
Predictions, you say this is something is going to happen, just let it roll and there'll be some solution, but you're not sure exactly what the solution is or what?
I think that it's not clear to me that there will be legislation on this, right?
I don't think there will be.
I think in the short term there won't be, right? But in the medium term there might be, right? I think the Supreme Court may have no choice but to re-engage here, and I agree with you completely. They don't want to, but I don't know if you've read it, but there was a cert petition filed within the last 2 weeks in the Athena case, which is frankly very powerful, and it basically says it's filed by Seth Waxman, a former Solicitor General, and it essentially says you've created chaos here, you have to deal with it, right? And that this is unremittingly bad. Everyone agrees. Whatever else the judges of the Federal Circuit may disagree about, they agree that this is the wrong outcome. And they can't fix it, you have to. And by the way, it ends with a little jab that I found funny, which says that you were the people who created these 3 extra textual exceptions.
Wow.
Right. So you're the ones who ought to intervene to make sure they're being applied properly.
That's actually interesting because usually Solicitor General is trying to reach a result, but in the most non-controversial, pleasing way possible. The gloves are off on this one.
I think Seth chose his words carefully there, right? But it's, calculated, I think, as a way of saying, look, you're responsible for this morass, right? Someone's got to fix it, and realistically, it's got to be you. And try to say to the court, look, I know you don't want to, but if you just say we're going to wait another half decade, then you're causing problems that have effects out in the real world.
All right, let's say the court denies cert. Will any of those 7 judges who said we'll wait for the Supreme Court say, well, we can't wait for them and we have to act on our own, and join the 5 judges?
Well, it depends, I think, on what cases come along. I think there will be cases where those 7 do. I mean, and I think this, that I have a case right now in which there's a cert petition pending, and the Supreme Court has asked for the views of the Solicitor General, which means it's, statistically, when they do that, there's a 50% chance they'll take it. We won in the Federal Circuit, so
this is the Vanda Pharmaceuticals
it's the Vanda case. But in the Vanda case, the court, including Judge Laurie, for example, who's in that group of the 7 that you mentioned,
and Hughes might be in that group too,
right? And they said, look, absolutely, we can deal with this, right? And so on that case, it was an example of one where they didn't feel their hands were tied. Now, the circumstances and the facts of the case are different, right? But you will continue to see cases that come along, and the court will continue to evolve
Yeah.
laws.
And Prost, the chief judge, dissented, and she is someone I think who actually is okay with this, and given like here, well, we don't have to go into that. That's so far
I
out
don't
of
want
it.
to, you know. I
Yeah,
mean,
I know you don't want to say anything about a particular judge, even though.
But what I would say is this. I mean, and look, I was, sitting next to Chief Judge Prost 3 days ago on a panel with her, right? And I have utmost respect for her, but I think that one of the things as chief, have a heightened sense of responsibility of how do I protect my court and not have it be put in a position of where there's a poor relationship with the Supreme Court that doesn't work well for us. And I think that in her tenure as chief, she's done a really good job under difficult circumstances of trying to improve that relationship.
No, I think actually she's a very good judge, and I just think philosophically she's more on the Breyer side than she is on the Newman Moore side. I could be wrong, but that's beside the point.
You can, people like to sort of handicap this and say who's pro-patent and who's anti-patent, and you can do that.
I said more on the side,
right? But they're, I'll
tell you, there's some judges on the federal circuit who would totally agree with me about what's going on. So
right, but they might not agree with you on a podcast.
No,
right.
All right. Well, we're going to delete this whole section
right,
so that Nick can actually continue to practice law. And all right, that we're getting to the point. Congress. I don't think Congress is ever going to do it. I think Congress does three things: nothing, which it does the best, codifies case law like fair use, or codifies a business agreement like Section 11. This is all copyright, cable and broadcast industry. First thing they'll ask you come up, do you all agree? If you don't all agree, they're not interested. Why? Because the Senate rules are one person can stick up their hand. You need unanimous consent to take away the week-long debate and make it like 16 hours. I don't know what the thing is. And unless you get unanimous consent, that bill won't even be brought forward, no matter how many people are for it. So you're in a situation where the Senate was created. This is outside the scope of this, but
very interesting.
Senate created a mechanism. It wasn't in the Constitution where it was dominated by Southern senators because there were no primaries or anything else. They were plantation owners, were in family after family member, and they were there to protect the South, which was a distinct commercial and every other way. Jim Crow laws, cotton, not industry, this or this. So they wanted to be able to stop anything where the rest of the United States was going to do something that would harm them. And they create all these rules about the law that they can stop anything that's going on. I don't think it's good government, but we have it. But it makes it, the court is it. Court is king now.
I think that's right. And I mean, also, I agree with what you just said about the historical background to this. Whether it's good government, if you look at it in the context of an economic expansion that went on for nearly 2 centuries, where there is a school of thought, and it can make some sense that limiting the ability of government to mess with that was good, as long as everything's getting better year over year. How bad can it be, right? But when you get to a place where it levels off or even starts to go into decline, then I think it's a real good problem systemically, right? And whether that's a much bigger topic than anything we're talking about. But I do agree that this type of law reform can only pass if every significant stakeholder says, "Okay, I'll accept it."
That's right.
And as long as the tech industry says, "Hell no," which is what they're saying at the moment, it's not going to pass, right? And that's what we see in these hearings is that it's all well and good to find the group of people who think the law is terrible, but if you've also got another group of people who think it's just fine, then nothing's going to happen in Congress.
Okay, so is there we have about a minute or two. Any final comments would you like to make?
I can say is the podcast is awesome, just like the conference. Best podcast in the universe.
Oh, I happen to agree, coincidentally. Anyway, Nick, thanks so much. It was great having you. And good luck and everything. Oh, all right. We don't have time for it, but I was going to discuss this particularly weird practice of Nick of race car driving,
We don't
risking his life. But I know you enjoy it, and I hope it's as safe as anything else.
Hugh, thank you very much, and it's been a pleasure.
The pleasure is all ours.